It's day 7 of Oscar Pistorius' trial in the North Gauteng High Court, and I'm joined in studio by Professor of Criminal Law at UCT, Professor Jonathan Birchall. Thank you very much for joining us.
It's a pleasure.
Now, court started today with something very interesting, something that many of us had not heard of. A witness was called to the stand and warned that he could incriminate himself. In fact, he was called a 204 witness. What is this?
Well, in terms of Section 204 of the Criminal Procedure Act, when a witness is going to give evidence that could incriminate him or her in a criminal trial, the judge is obliged to warn that witness that he or she has to answer the questions, has to give evidence, but that if he or she answers honestly and frankly, then the charges that could result from the evidence will not arise. In other words, that person will be discharged as far as those charges are concerned. If, however, the witness does not answer honestly and frankly, then he could be prosecuted for offences that arise from the evidence that he's given.
Who decides if he is answering truthfully?
Well, obviously the judge has the decision on truthfulness, whether he's honest and frank. And he has a legitimate expectation that he will be discharged if he answers the question honestly, or the questions honestly and frankly. But the judge ultimately decides whether he has answered the questions honestly and frankly. And of course, the charges that may result in this particular case would be charges relating to firearms.